Hi, I'm Giddy Mammon. I'm from the law firm of Mammon, Sandlick, and Kingwell. Today we have one of our licensed professionals, Daria Barmal, with us today. We're going to be talking about overseas spousal applications and inland spousal applications. And Daria, we're always talking to clients, which should they do? They're not sure, they ask us. So it's going to depend on a number of factors. So let's first go over the inland process. Daria, you're going to deal with the overseas process,
yeah.
okay? All right, so here we go. First of all, in Canada, you can sponsor your spouse, you can sponsor your common law partner, you can sponsor your conjugal partner. For the inland process, you can only sponsor your spouse or your common law partner. What's a common law partner? A person who you are living in a relationship of permanence under the same roof for at least 1 year. Okay, you have to be under the same roof. If you're not, it's not going to work. So please be very careful if you define yourself as a common law partner. Okay, so to apply inside of Canada, rule number one, you've got to be in Canada. The time frame for such an application is roughly 12 months. The government posts on cic.gc.ca their average processing time. That only applies in 80% of the cases, but that gives you only a rough idea. The experience that we have in the office is that they can range anywhere from maybe 6 to 8 months to even 16 months. In complicated cases, they can take 20 months or even longer. To be sponsored from inside of Canada, the applicant does not have to be in legal status, but be very careful. There are certain exceptions. For example, if you are in Canada and you came to Canada after you'd already been deported from Canada and you returned without the consent of the minister, without authorization to return to Canada, you are not eligible for this program. There are other considerations also, there are other exceptions. Please be careful if you're going to apply inside of Canada. Now, the great thing about applying from inside of Canada is that at the same time that you apply for permanent residence, you can submit a separate application for a work permit. The government fee is what, about $255? You put the applications together. In 3 or 4 months, you should get an answer on your work permit. It'll be an open work permit. That means it'll allow you to work anywhere you want. There will be some conditions involving food, children, and other things, but for most people, it'll be sufficient. Okay. Now, just because you applied for permanent residence does not mean you don't have to extend your status if you have status. So if you're on visitor status, please make a timely extension of your visitor status. Same thing for workers, same thing for students. Now, typically, we are not seeing as many interviews as we did back in the day. Today, about 80% of the cases, I'd say, are no interviews are required. That means if you submit good enough documentation, the officer, without ever meeting you, will be able to make a decision whether or not your relationship is genuine or not. If an interview is required, there's something unusual about your application. Maybe you've only known each other for a very short time. There are questions as to how long you've been living together. Anything about your history, an interview will be called upon, and the case will take longer. Now, the most important consideration for inland cases is as follows. Is there a risk that this case is going to be refused? If you feel that your case is marginal or weak, or there's something unusual about it, and you're afraid that you may have to appeal that decision, you only have the right to seek permission of the federal court to bring an application for judicial review. What does that mean? That means the federal court does not hear every appeal for sponsorships, okay, for inland sponsorships. What that means is they're going to take a look at the merit of your arguments. If they don't see any merit, they're not even going to hear from you or your lawyer. You cannot introduce any new evidence into your application for judicial review. That means whatever you submitted, whether it was good or bad, that's all you can rely upon. You cannot testify at your judicial review, only your lawyer can attend. You cannot use a consultant for the federal court application. The chances of success on a federal court application are not as good as if you applied in the overseas program. Duria, can you tell us a little bit about the overseas program?
Sure. So, a couple of considerations that you want to make. You can be inside Canada physically, or you can be outside Canada in order to do an overseas sponsorship application. Average processing times for an overseas application, give or take about 12 months. Again, just like Giddy mentioned, depends on whether you're going to have an interview or not, depends on whether you're going to need the authorization to return or not. So quite a few kind of steps of the application would determine the length of time it would take to process. The application process, any overseas application is initiated in Canada. There's a case processing center in Mississauga, Ontario, where your initial application is filed. It goes through an assessment process for the sponsor's eligibility, and then the application gets transferred to the visa office overseas, depending on where you live, depending on where you have permanent resident status or temporary resident status. The chances of interviews overseas are little higher if you've got any kind of previous immigration history. So you've come here to Canada previously, you've visited, you've overstayed, you've even studied here, and sometimes you don't get options of applying for permanent residence. So one of the key reasons again is to figure out that your application, your relationship is genuine and you're not making this up for immigration matters. Most cases, only the applicant is required to attend these interviews overseas. Obviously, the sponsor is free to attend if they want to, but the applicant is mandatory. If you lose an overseas sponsorship, if you're denied, you do have the right to appeal that decision at the Immigration Appeal Division here in Canada. The sponsor would file an appeal, and there's a limitation of 30 days from the date of refusal to file that appeal. A couple of advantages on filing an appeal on a refused sponsorship: you do not have to ask for permission to appeal. You have a right to counsel at the appeal. You have the right to file new and better evidence regarding your relationship. You have the right to testify on an appeal, and the applicant overseas is usually asked to testify on the phone. That kind of overall covers my overseas portion, and I'll hand it over to Gilly on what your best option is.
So the question is, which should you do? Should you do an overseas or should you do an inland? First of all, if you need to work and you're inland, you want to do the inland application because you can get to work pretty quickly in a few months. If you're doing an overseas, you can't work in Canada until the process is finished, which could take a year, unless you qualify for work permit through some other method. The inland process, if you need to leave the country during the inland process and you can't get back in, chances are that application is going to be aborted and canceled by immigration. So if you have to travel, think about it. You may need a visa to come back to Canada, or you may need an ETA to come back to Canada, and who knows, you may even have difficulty trying to maintain your status in Canada. If you have a criminal record, definitely do not apply in the inland process. The immigration officer has to refuse your application, and you're headed right towards a federal court judicial review, which are much more difficult to win than the appeals to the Immigration Refugee Board. So if you think you're going to be refused, if you think there's something a bit wonky about your relationship that the immigration officer may not get, you're much better off applying overseas, because you're going to have much better rights of appeal. You'll be able to testify, you'll be able to have a lawyer in the room with you, you'll be able to bring new evidence, and it'll be a much easier go for you. I hope these comments have helped you, and if you have any more questions, please give us a call. Giddy Mammon, Duria Barmal. If you have any questions, visit us at www.migrationlaw.com or give us a call, 416-862-0000.